The Bonneville County Courthouse stands at the center of a case that has horrified the local community as Brandon Robert Phillips prepares to learn his fate. A 42-year-old resident of Ammon, Phillips was originally facing 3 counts of lewd conduct with a child under the age of 16. Serious felony charges that each carry a potential life sentence in Idaho. Through a plea agreement, Phillips entered a guilty plea to count 3, which specifically involved oral to genital contact. However, the gravity of the case extends far beyond a single legal count. The victim is actually Phillips' own daughter, who reported a pattern of ongoing abuse that allegedly began back when she was just 12 years old. So as the gallery fills with family members and concerned citizens, the primary tension lies in Phillips' conflicting narratives. Despite his formal guilty plea to the court, records indicate that Phillips has consistently maintained his innocence to his counselors and family, even allegedly threatening his daughter that her mother and siblings would be put out on the street if the truth ever surfaced. Well, today the court must decide if his 11th hour apologies and low-risk evaluations can outweigh the prosecution's demand for a lengthy prison stay, a sentence framed not as a response to a momentary lapse, but as the consequence of a calculated and cold choice that shattered a young life. Well, we're about to find out.
All rise. This court is now in session. The Honorable Brendan Taylor presiding.
Please be seated. Before we get started today, we do have our press here today for at least one of the matters. Those who are here in sentencings that we have victim-based crimes, my order is always consistent that I don't want victims identified. And so my order has been specific not to have the victim on camera. I would just admonish that if the victim's name is mentioned in any of the proceedings, that not be included in any report by the press. And I'll encourage those who are making statements in court to simply identify the person as the victim or by initials only to protect the identity involved. We're going to go on the record with the first matter on the docket, CR 10-24-2242, State versus Brandon Robert Phillips. We have Mr. Phillips here with counsel of record, Mr. Smith. Mr. Harris is here on behalf of the state. This is the time and place for sentencing on this matter. Are parties ready to proceed? Mr. Harris?
Yes, Your Honor.
Mr. Smith?
Yes, Your Honor.
Just by way of information, the criminal information was originally filed in this matter on April 16, 2024. It was subsequently amended. There was an arraignment on April 23, 2024, where a not guilty plea was entered to 3 counts of lewd conduct with a child under 16. The amended information included the same 3 counts, which was filed on May 1, 2024. There was several hearings leading up to the resolution of this case. There was a change of plea entered on the record on June 16, 2025. That was shortly before I took the bench as the judge who was then assigned the case. After I was assigned the case, there had been an order to submit a pre-sentence investigation report that has since happened. The court has had a chance to review the pre-sentence investigation report, which included a psychosexual evaluation as well. Mr. Phillips, have you had a chance to review the reports with your attorney?
Yes, Your Honor.
And is there anything in those reports that needs to be corrected or changed at this point in time?
Your Honor, there is not. We will make some argument accordingly in the opportunity, but no changes.
All right. Is there any objection to me relying on that report?
No, Your Honor.
And is there anything that you learned as a result of looking at that report that causes you to want to withdraw your guilty plea in this case?
No, Your Honor.
All right. And are you fully satisfied with the advice of counsel and your representation by Mr. Smith in this proceeding?
Yes, Your Honor.
Very well. As you sit here today, are you under the influence of any substance or condition that impairs your ability to understand what we're doing or think clearly?
No.
And you read and write English just fine, I presume. Is that correct?
Yes, sir.
With regard to how we're going to proceed, I'm going to hear from the state. If there are any witnesses or statements that would like to be made, I'll hear those. I'll let the defense present any statements or witnesses that they would like to call, and then I'll let Mr. Phillips address the court before I make my decision as well. So I'm going to start with the state side. Do you have any witnesses or any statements that you'd like to have presented to the court?
Yes, Your Honor. I do have at least 2 victim impact statements. I'll be starting with the victim's father and followed by the victim. She will be present, but her statement will be read by her counselor.
Very well. You may do so. Statements, both in support of the victim as well as in support of the defendant, that were included in the materials that were provided to me with the pre-sentence investigation. I was able to read through all of those statements. I'm considering everything that I've received as I'm going to prepare for sentencing here today. I just want to make sure that those who wrote understood that their words have been read, considered, and I weigh everything that I received. Mr. Harris.
Thank you, Your Honor. I spent, I'm sure Your Honor did the same thing, but I spent quite a bit of time in counsel too, reviewing the psychosexual, the PSI, reading the statements that had previously been supplied to the court, and I always have a difficult time with those. In this particular instance, having a little bit of foreknowledge of the PSI, or rather the victim impact statements from the PSI, I felt like that would speak probably volumes toward the reasons for the state's recommendation. In this case, we were able to get to an agreement that included the defendant pleading to the 1 count of lewd behavior and lewd conduct, and be free to argue. The PSI recommends I don't know why I didn't put that, but it does recommend a period of incarceration. I noted as I went through in mitigating circumstances or mitigating factors that Mr. Phillips has a very low LSIR of 10. At 41, is young enough to benefit from the opportunity to return to society after that period of incarceration, especially if he receives programming while in custody. And of course I noted from the psychosexual that it showed Mr. Phillips has a below average risk category based on at least 2 tests that seem to be quite standard for psychosexuals. I noted also that there seemed to be, I'll call it at least a little bit of ambiguity on the subject of what would happen if Mr. Phillips were placed in a similar situation as the one that brings us today, that is a position of power, a position of responsibility, and one that brings him in direct contact with a younger female. It seems to imply that although he may not seek those opportunities, you might find them a little irresistible. That is to say, he might still recidivate. So although he does have a low SIR and below average in any of the risk categories from the psychosexual, there is still a risk. And that risk would imply a need to, and I believe, follow the PSI and keep a certain amount of time away from society for the protection of society. Something that I also found troubling was that although again we did get a certain amount of cooperation getting to an agreement, that Blair Gardner, the licensed clinical social worker that's been treating Mr. Phillips since March of last year, says that he's now experiencing anxiety, depression, that is Mr. Phillips. And an interesting thing, a note that he mentioned in addition to the anxiety and depression that Mr. Phillips is dealing with, Mr. Garner confirmed that Mr. Phillips has always maintained his innocence in this case. That I find difficult relative to the things he has admitted that he would consider himself innocent. That again isn't surprising, but I'll say somewhat disappointing. And it may go back to something that I think I've heard in this court several times, and the court addresses often when it hears it, which is the idea of mistake. People make mistakes. But as has been outlined here, this was an activity that went on for a number of years. There was no mistake. There was a choice. Now, from my studies, I believe that some people make choices, and sometimes those choices are based on a mistaken apprehension of the outcome of those decisions. And I think that may be what we had here. At the end of the day, we still have someone who was placed in a position of trust that had the power, the authority, and also the responsibility over younger people, in this case, one of those younger people being the victim, and abused that position. I think the abuse itself was, again, not a mistake, maybe a mistaken apprehension, but a choice. Relative to that abuse, the state is also a victim, obviously less so than the principal victim in this case. But again, the state has seen that a wrong was done, a law was broken, and now for the protection not only of the victim but the rest of society, I believe that it's important that the defendant have the opportunity to take responsibility. And today is definitely the time for that. The state believes that the punishment should reflect the degree of importance that Mr. Phillips held, the degree of responsibility that he held. And so the state recommends a 7-year fixed and imposed an 18-year indeterminate sentence. State requests that the NCO in this case, I don't know the expiration date of that, but that it run at least for the term of 25 years from today's date. I would note on the 29th of this month, or thereabouts, the state filed a cost motion for $1,766.37. I would note that cost motion should be ongoing because it reflects the cost of counseling and treatment for the victim, and that treatment will be ongoing. Unfortunately, this conduct has a ripple effect, not only affecting multiple lives, but going beyond just the time, the date that it happened for, like although the victim may have the opportunity to be a transitional character in her family and make changes, improve her life, at this point, right now, we're looking at she'll need a great deal more counseling, and that cost needs to be able to be carried and be the responsibility of the defendant that caused that injury. And with that, I'll thank you.
Thank you, Mr. Harris. Mr. Smith.
Well, Your Honor, thank you. We're here in a courtroom that's seen a lot of cases, and unfortunately, many of the cases that come to this courthouse are so tragic, so unpleasant, and those of us that work in the system see these and work within the system. But there's one thing that I'm still grateful for, even though we see so much carnage within our society, frankly, as different cases come to this courtroom. And that is the fact that there is a set of rules and a set of procedures and a set of statutory schemes and 4 related goals to sentencing that are laid out for Your Honor to consider before passing judgment. And I recognize this court takes that seriously. I'm grateful that we as a society are still at a point where we have decided to allow the court system to deal with these kinds of things. We're no longer the wild, wild west where people can just take matters into their own hands. I see many, many times in the press after we're done with these cases that that's exactly what a large amount of society would like. It's interesting to me, though, that those who advocate for that, they don't advocate for that when one of their own family members is in that situation. They just would like to impose that upon others. It's part of the binary thinking that comes along with today's society, which is very unfortunate. And before I make this comment, I want to make it very clear, I do not believe at all that the statements by the victims were binary. Very impressed with how they presented themselves, and want them to know that I recognize what they said. And it was heartfelt, and I realize that. When I speak of the binary thinking that I'm about to talk about, it is how society expects you as the judge to handle these kinds of matters. And I want to make that distinction. We're a clickbait society. We're on social media, and the bias feeds us whatever we're looking for, and pretty soon we lose all ability to critical think. It's good or bad. It's good or evil. People can't be nuanced. You're either with us or you're against us. I don't think I've ever seen such polarization in our society after doing this for 30 years as I have in the last few years. It almost feels as though we've lost the connection of community to be able to talk about things and to be able to reach resolutions after critical thinking and after realizing the nuance in all of us and after realizing the empathy that we all need to have for one another in life, because we all make mistakes. We don't all make tremendous mistakes that can cause such tragedy. Those are special cases, again, that the court many times has to hear, whether somebody's been injured in a horrible accident or whether someone has committed a crime, or as my client who sits here today within a family in a position of trust who made a mistake. There's just no doubt about that. And I appreciate what Mr. Harris says. Was it just a mistake? No, it's more than that. And my client recognizes that. But here's one little thing that I want to point out. Why do we have counseling and psychosexual evaluations? In the old days, we used to have psychosexual evaluators come and testify. And frankly, I think that sometimes the court system's so full that we counsel try to do things in a quicker way to be efficient because we know what the calendars of the court is like. But in those days, we had someone who took the stand and could educate the people here and the people in the society about how this works in a case like this. You will never have an expert, not anywhere around the country in my opinion, who does psychosexual evaluations and counseling that does not indicate that when someone starts in that treatment, it's the human ability to not see yourself reflected in the mirror. You have to do counseling to eventually see that reflection and accept the responsibility in a full way. That's why we have the counseling. If everybody came to court in a situation where they could completely accept the full responsibility in front of the public, in front of their loved ones, in front of the court, which, let's face it, that's a hard thing. Many of us, if we were in that spot, would do the same thing. We'd probably minimize, we probably would have a hard time looking at ourselves in the mirror, and because of that, we would deflect until we learn through counseling how to let those defenses down and see ourselves and to recognize how we can prevent this from happening again. That's what the counseling does. That's why it's so critical that people in my client's situation get the treatment. Many, many people would just say, guess what? Just lock them away. That's not feasible. It is more feasible for us to get them the treatment that they need so that they can see and understand what the victim's going through, so that they can see and understand how they made those thinking errors, so that they can see and understand how to be safe in the community. Now, my clients already started that process. My clients started that process being proactive by getting into Blair Gardner. The thing that's so heart-wrenching is we never have people from the community on the courthouse steps or the state house steps asking for funding for the very critical things that are most affecting our society. And that's things like this, with treatment options and opportunities. Do you know, if I had somebody come into my office today and say, I've been having horrible thoughts and I feel like I'm on the verge of abusing a child, I could send them to a counselor, but not one trained for that kind of scenario. The ones that are trained for that kind of scenario, there's too few of them. There's too few resources. We don't even offer those services. My client can't even get those services after he's committed the crime without pulling some strings, because they only want to take those who have already been adjudicated into those classes so that they can learn. These are the things that society doesn't want to know about. They don't want to hear about it in the Southeast Idaho news clip. They don't want to understand that we are lacking in those services, and that even somebody who may want help can't even get that help until a certain point, because we're so bogged down and there's not enough funds and there's not enough people rendering the services. We're waiting longer for psychosexual evaluations. We're waiting longer for counselors. Blair Gardner's almost retired. He only does this because he knows the need, and he's maintained a practice beyond his retirement because he feels a responsibility to the community, for heaven's sakes. We only have 2 evaluators in Southeast Idaho, and Dr. Hatzenbuehler is about ready to retire. I have no idea what the court system's going to do when she does. These are issues, again, that when we binary think, we don't want to talk about. We don't want to talk about how to fix those problems. We don't want to talk about the reality that when people engage in counseling, we do have low recidivism rates in a crime like this, with somebody with a low LSI score and with somebody with a low risk on the psychosexual evaluation. They're treatable. They're amenable to treatment. My client, for the last couple of years while we've been working through this case, has been safe in the community. There's been a child protection action that's been there working as well. There have been plenty of steps taken to try to remedy and show that he's moving in the right direction. Now, does that get where we need to be for the 4 related goals of sentencing for the victims? No. But is it a component? Absolutely. Absolutely. Rehabilitation is one of the things that this court, and this is back to where I started, the binary thinking is going to continue to go on in society. In fact, I think it's going to get worse. And I think we're going to see things that none of us hope to see. But I can't change that. This court can't change that. But where we can make a difference is in a courtroom with the seal of the state of Idaho and with the swearing in of a judge after a ceremony and with our dictates of ethics and rules and procedure to mete out justice for the victims, for the defendant, and that weight is heavy. You know, since human existence, it's been a challenge, right? The wisdom of Solomon. Who's going to make these decisions? What is justice? It will not matter what you do today. There will be people that will castigate the system. They will castigate the prosecutor. They will castigate you. They will castigate us. This is a system they say that has failed. And yet, it's the system that society is more than willing to dump their problems on. A divorce, a property dispute, a water dispute where somebody hits somebody over the head with a shovel. These are all the things that happen in society, and we could go on for days and talk about what goes on in society. But the court is supposed to have the knowledge and the wisdom to fix it all. And you're supposed to do it with a penny. You're supposed to do it without a real budget. You're supposed to do it without real resources. You're supposed to do it without those things that we need. So what do we do? And what is justice? I don't know. I've seen it for 30 years. I've seen cases like this when I started that were almost always in automatic probation. Do I think that was fair? Do I think that was just? I don't know. I just know what I saw for years. Then we moved into a realm where retained jurisdiction was often what was given because we could start somebody down this path of treatment because we know they're going to be out on the street again. So treatment becomes a real answer, a real statistic that we can point to say if we get people the right treatment so they can view themselves in the mirror and they can start to understand the empathy that needs to be there for a victim. They can get to a real point of being a human and recognizing their role moving forward. That has to be done. And here's the great news. Not very often, but many times in my career, I've seen a family scenario come full circle many years down the road where there's forgiveness, where there is a new reality, where everybody can move forward in a positive direction. It'll never be the same. It'll never be forgotten, nor should it. But it can be better. It can be better. So, Judge, I guess I just would come to the point of my recommendations. But I don't think we can be flippant about the binary thinking that's going on in the community. And I don't think we have a community that wants to educate themselves about what a judge really does, about what you have at your disposal, about the tools that are used before a sentencing. They just assume that you hear a 10-minute argument like they see on TV and you make a snap judgment. They don't realize that you've reviewed a psychosexual evaluation. They don't realize that you've reviewed statistics from the Department of Corrections about incarceration and what other cases have done in similar situations around the state. They don't care to think about you having reviewed a PSI or heard from the victims or heard from family members that support my client and what he's done in his life. I think one of the most perceptive things that I heard today was from the victim herself, when she said something along the lines that his good parts don't excuse the horrible acts that he did. Never has more truth been spoken. Two things can be true at the same time, which is where society has lost their ability to realize that. Somebody can be a good person and have lived a great life and done a lot of fantastic things not only to benefit their children, their parents, the community, but they can also do something that's terrible. And that's something we also teach children. Not just about accountability, which needs to be done, and my client's here today for that accountability, but that we all, at some point, can find redeeming qualities if somebody is willing to turn from what they've done, make amends, pay the price, and move forward. That's been a concept that we for a long time have recognized in our society. Some people put it in a religious context. Some people put it in a philosophical context. Some people just wrap it in a moral context. But if we as people can do that, it's the concept that we all write a book of life. And some of those pages in our book of life can be messy and can be ugly and can be tragic. But the overall story can be a positive one with a positive ending. And that's where my client can be if given the right opportunity, as well as meting out the justice that the victims seek. So only you are the one today that get to make that decision. I now would propose to you a couple different things to think about. This court could retain jurisdiction and see how my client performs in incarceration and in treatment. I've had judges, even when somebody comes back from retained jurisdiction with a perfect record, say to my client, I'm not going to put you on probation. I'm still going to send you to do some time because I think you need to. But if you were to do something along these lines of retained jurisdiction, at least you maintain jurisdiction to see how he's doing, to see how he's performing, to make a final judgment at the time that he would come back from retained jurisdiction, to see whether he needs more time, more penalty, more structure, or not. It is a safe way for you to go because you maintain all of the control. Now, if you don't do that, I understand. Again, you're going to mete out justice the way you think it needs to be done today, and I trust this court. But if you do a prison term, I can tell you that just here in the last 3 years, in cases of my own, I haven't seen a case like this that has gone with these circumstances and this charge, even thinking of other relevant conduct, more than a 5-year fixed. That's just my experience. I understand that there are other experiences, but the state has asked you for 7 fixed. And here's what else we have to realize. I do parole boards regularly. I am not seeing the parole board release people on the first or even the second time with cases like this. So this court has to recognize that a 7-year fix is not a 7-year fixed sentence. A 7-year fix is more likely a 10-year fixed because the parole board is going to keep someone for a few years beyond that fixed portion of time. I think this court has to recognize that when giving a fixed sentence if you're going to impose a prison term. Because at the end of the day, the sentence has to be just. The sentence has to be based on the related goals that you have the responsibility to mete out. The sentence has to take into account that the statute starts by basically commanding the court to consider probation first. That's why I think these things have to be considered. And I will be forever grateful that the nuances and the critical thinking that comes into play in making these decisions only happens in one place on earth any more than I know about. And it's in this courtroom. It is the only place that I still see some reasonableness and some critical thinking and some non-binary thinking in making decisions. And maybe that's appropriate in our society, that this is the one place. It doesn't happen in politics. That's gone. Long since lost. I think never to be regained. But the courts have to be the place where we continually check ourselves, check our bias, check our binary thinking, rely on the reports, rely on the psychosexual evaluation, rely on the things that we know and understand and see every day that the community doesn't, and that they want to ignore, and that they want to castigate the system, even though they're the ones laying their biggest, most critical problems on, and asking us to do it with a penny. This still is the one place that can happen. And you are the only one that has that responsibility. So with that, we would submit with the concepts that we've given you, hoping that you can find a way today to do justice for everybody who is in this courtroom. Thank you.
Thank you, Mr. Smith. Did you have any other statements, witnesses, or other information beyond your client speaking?
Thank you, Judge. We do not, because his supporters have given you letters, and my client will just allocute and address the court at the appropriate time.
All right. Mr. Phillips, now is your time to address the court. You're welcome to tell me anything you'd like me to consider in my sentencing.
Thank you, Your Honor. I appreciate the time I have to do this, and I appreciate everyone for being here. Almost everybody in this room is somehow related to me, distantly or directly. And the fact that everybody is here because of my decisions and my actions, and to see all the people that every single person that I love in this world has suffered because of the decision that I made, my actions. Whether it be my family or, I held my daughter last night as she cried. And when I try to tell my son, he doesn't believe me. He just keeps saying, we're going to go swimming tomorrow, Dad. And I'm like, I might not be able to be there, buddy. And he's like, no, we're going to go swimming. And I want to apologize to the community, this court, my family, for what my actions put them through. And more than anyone, I apologize to the victim, my daughter. I am so sorry that my actions have hurt you. I am so sorry that I failed you. We have felt your absence so deeply. And not a day has gone by where I don't wish that I could have done better, been better, and provided better. There's not a day goes by that I don't see this as my greatest mistake. And I do everything I can every day to try and make up for it, and I will for the rest of my life. To try and be better and to be there for those that I care about and those that care about me. Thank you for the time to be able to say this, and I appreciate it.
Thank you, Mr. Phillips. Counsel, is there any legal reason I should not proceed with sentence at this time? I'll start with the state.
No, Your Honor.
Mr. Smith.
No, Your Honor.
Mr. Phillips, based on your plea of guilty, it is the judgment of the court that you are guilty of the charge of lewd conduct with a child under the age of 16 in violation of Idaho Code 18-1508. I have reviewed the pre-sentence investigation, as I mentioned. I reviewed the psychosexual evaluation. I reviewed the statements from a large number of individuals involved in this case, both in favor of the victim and in favor of the defendant, in support of those respective individuals. I did note in the pre-sentence investigation your age, the low LSI score, prior record being fairly light, only one juvenile charge before, as being mitigating factors. I noticed other aggravating factors. Those would include the act itself. The concern the court has is there are multiple versions of what have happened in the court record. This is noted in the psychosexual evaluation as well. There's the version that the defendant has expressed and told, which I find to be largely consistent from the time she initially started reporting, that is supported by family members and other close individuals to her that have reported changes in behavior at the time that the alleged incidents were to have begun. There are statements that you have made to law enforcement, to the pre-sentence investigator, to the psychosexual evaluator, that certainly minimized. The one statement you made under oath was when you were here in front of Judge Taney, who took your guilty plea. I listened to that because I wanted to hear what you were admitting to, because there was that discrepancy as to the version of events that were reported in the psychosexual evaluation versus the defendant's version of events. And you had admitted under oath that you committed the acts that were outlined in charge 3, count 3, which is what you pled guilty to, which is different than what you told the psychosexual evaluator. You noted your counselor's records that stated you've always maintained your innocence. Friends that wrote on your behalf that you'd always maintained your innocence. I noted the victim's statement that you told her that you would tell everybody that you were innocent to your dying breath, was, I think, the phrase that she had used. I looked at the police report, and the child's mother initially did not want to talk to law enforcement, but then after the children were removed from the home, she did talk to law enforcement. She admitted that she was previously afraid and told the officers what you told her to say. She admitted that the child told her at about age 12 that you had done inappropriate touching, and that she confronted you about that you admitted what had happened and promised to stop. That you also told her that she and the children would be put on the street if she told anyone, and that no one would believe her. Then she talked to the child in 2023 and found out this was still ongoing. I read Ms. Phillips' statement where she encourages the court for leniency to allow you to stay in the community. I looked closely, and she never refuted what the victim in this case has reported to have happened. I consider the statements from the victim and her biological father and the supporting statements from family. What you had admitted to in count 3 was essentially oral to genital contact. That's what you admitted under oath. What you told the evaluators and what you told family is something different than that. And the concern I have, and I appreciate Mr. Smith's comments, are that people don't start off wanting to admit the full truth. People don't start off with a position that they're able to acknowledge everything that they did that was wrong when they're in counseling, that that's a process, and that you have been in counseling for a while. But throughout that counseling, as the state pointed out, the counselor reports that you've maintained your innocence to the charges. In the psychosexual evaluation, it notes that you don't think counseling is necessary, that treatment's not necessary, but you're willing to do it if the court orders it. Until we start with a position where there's an acknowledgement of the behavior, treatment is not going to be meritorious. That's the concern the court has. And your counsel is correct. The court is guided by law. And that's what I consider in deciding and sentencing. I swore an oath to uphold the Constitution and the laws of the state of Idaho. In State v. 2 Hill 103, Idaho 565, the courts are guided to look at 4 primary factors in fashioning a sentence. That includes protection of society, deterrence to the individual and to public in general against committing the kinds of crimes that are before the court. The possibility of rehabilitation is certainly a factor the court is required to consider, and punishment or retribution for wrongdoing. So those are the factors the court is required to weigh in deciding what the appropriate sentence for the crime that you have admitted guilt to would be. The court is further guided, if I'm considering incarceration, which I am in this case, by Idaho Code 192521. And as your attorney had pointed out, this is the law the legislature in the state of Idaho has passed that guides the courts in how we must think about sentences. And the first line in there states that the policy of the state of Idaho regarding sentencing of persons convicted of a crime is as follows. Unless otherwise provided by law, under subparagraph 1A, the sentencing court should first consider placement in the community. So that's where the court has to start. There are a number of factors that the court considers when deciding whether placement in the community is appropriate. Those would include whether the defendant's criminal conduct caused or threatened harm. In this case, there is clear harm that has been caused by the conduct. Second one is whether the defendant did not contemplate that his criminal conduct would cause or threaten harm. It would be inconceivable to think that the conduct that you've admitted to would not be the kind of conduct that a reasonable person would anticipate to cause harm. That there are substantial grounds for excusing or justifying the conduct. I appreciate that nobody has suggested that there is a good reason to excuse the conduct. The version of events that you have told people, however, does try to minimize and does try to provide some sort of an excuse. When the version stated to the psychosexual evaluator was that the child slipped under the covers, spooned up next to you, you didn't really know what was going on because you were asleep until the conduct had occurred. I think that tries to provide some excuse, but here today you're acknowledging and admitting, and before the court back in June, you admitted to the allegations in count 3. Another factor is whether the victim induced the commission of the crime. The court's not finding any evidence that the victim induced the crime here. Notwithstanding some of the statements, the court does not believe that a child induces the kind of crime that's before this court. The court has to consider any history of delinquency or criminal conduct. That's where it weighs in your favor, where you've had a fairly clean criminal history with only one juvenile charge. And the character and attitudes of the defendant indicate the commission of another crime is unlikely is another factor the court considers. And the court has concern here that this conduct is alleged to have occurred over a lengthy period of time. The court only punishes for the incident before the court. However, I have one count of lewd conduct that is before the court that has been admitted. The court has concern about the report of ongoing and the protection of others. Then the court is guided to consider factors that weigh in favor of a sentence of imprisonment. That there is an undue risk that during the period of suspended sentence of probation, the defendant will commit another crime harmful to another person. Given the nature of this crime, I'm hopeful that that wouldn't happen, but I don't have enough confidence that there couldn't be another victim. I look at the psychosexual evaluation that says that there's a low risk to reoffend. There is a statement that you're in a moderate range, given the facts of the case. However, the court has concern, as was pointed out in the pre-sentence investigation, that this psychosexual evaluation did not include a polygraph portion, which is often the case. The court could have required you to go back and do the polygraph portion of the psychosexual evaluation, but the court felt that everybody was ready for the day-to-day, and the court was not going to make people who have been waiting for an answer and have been struggling with the facts in this case and have been preparing for sentencing to have that pulled out from under their feet at the last moment. So the court did not require that. But that's something the court considers, is that the psychosexual evaluation did not include that. The psychosexual evaluation also noted the stark difference between the versions of events and the version of events that you had explained to the evaluator versus the version that the defendant had, or that the victim had expressed. The court also considers whether a lesser sentence will depreciate the seriousness of the crime. Certainly these are crimes that the court views very seriously and the society views very seriously. The court is not guided by public sentiment and tries to appease the public outcry that we see in the news. That's not one of the factors the court considers. The court considers whether the statute is being followed. If I were to give a lesser sentence, the seriousness of the crime would be undermined. additionally, whether imprisonment would be an appropriate punishment as well as a deterrent to you and to society in general. And then finally, whether the defendant is a multiple offender or a professional criminal, which does not factor in at this point. So having weighed all those factors, having considered the evidence before the court has decided that the following is the appropriate sentence. Under count 3, the court is going to order a sentence of 7 years fixed, 15 years indeterminate, giving credit for, I believe, 2 days served on this case previously. One day served. It's like 1 day served. Fine in the amount of $2,000. Court costs. Is there any contest to the restitution amount, Mr. Smith?
Your Honor, some of that has just been given to us. I know a lot of times the state gets 30 days. We just need a little time to review what's been submitted, and then we're happy to let the court know.
Very well. The court will allow any additional information for 30 days in favor or against the motion for restitution, and then once that's been submitted, the court will have a hearing on the proper amount of restitution in the case. You would have 42 days to appeal my decision. Counsel would be appointed if you can't afford counsel. You would have 120 days to file a request for relief under Rule 35 if you thought the sentence the court has issued is illegal or too harsh. And you have 1 year and 42 days to file for post-conviction relief. You'll need to submit a DNA sample and a thumbprint, as this is the first felony conviction. I will remand you to the custody of the Sheriff of Bonneville County for execution of the sentence. Is there anything else to take up, Mr. Smith?
Your Honor, there is not. We'll leave the pre-sentence report right there on the table.
Appreciate that.
Thank
Both
you.
the state and defense will try to. We are adjourned on this matter. The court's going to take a short break before we commence on the next matter.
Let's go.
District Judge Bruce L. Pickett delivered a sentence that reflected the gravity of the betrayal involved here. Rejecting the defense's request for a rider or retained jurisdiction, the court focused on the long-term nature of the abuse and the conflicting narratives that Phillip provided to his evaluators. Judge Pickett noted that while the law requires the consideration of rehabilitation, the protection of society and the seriousness of the crime against his own daughter necessitated a significant term of imprisonment. Brandon Robert Phillips was ultimately sentenced to a total of 22 years in the Idaho State Penitentiary. The judge ordered a 7-year fixed term, which Phillips must serve in its entirety before becoming eligible for parole, followed by a 15-year indeterminate period. In addition to the prison time, the court imposed a 25-year no-contact order to protect the victim and ordered Phillips to pay $2,000 in fines, plus court costs. With the bang of a gavel, the court closed the chapter on a case defined not by a single mistake, but by a series of devastating choices.